I am attorney Maricris Bathan-Lasco. This is my virtual classroom. Welcome to my YouTube channel. In this channel, we shall aim to simplify the law. We shall explain concepts and principles of law in under 10 minutes. In this video, we shall talk about quasi-contracts. What are quasi-contracts? These are juridical relations arising from lawful, voluntary, and unilateral acts by virtue of which the parties become bound to each other. Again, these are brought about by lawful, voluntary, and unilateral acts made by one person which benefited the other. And because of that, the law creates this tie between them. The principle behind this is that no one must be unjustly enriched at the expense of another. What are the two types of quasi-contracts, or the two kinds of quasi-contracts? One, you have the Negotiorum gestio, or unauthorized management. And second is your Solutio indebeti, or undue payment. What is Negotiorum gestio? Negotiorum gestio, or unauthorized management, happens when one person takes charge of the business or of the property of another without authority. But because of such taking charge of the business or of the property of another, this other person who owns the property or the business benefited from it. And because he benefited from it, even though such management was without authority, it is but right that the owner of the business or of the property who benefited from the unauthorized management must give recompense or must compensate that other person who took charge of the business or of the property. Our usual example on Negotiorum gestio is when one leaves his house unattended. He goes on a trip and then he leaves his house with no one taking charge of it. If such house gets razed by fire and no one is taking charge of it, and then your neighbor tries to help out and tries to save as much belongings that he could in your house while you are away. This is an example of Negotiorum gestio, or unauthorized management. There was no authority from you who owns the house for the neighbor to save your belongings. But because of your neighbor trying to save your belongings, you benefited from it. The law creates a juridical relation between you and your neighbor, where you will have to compensate your neighbor for whatever he may have spent in saving your belongings. That is why your quasi-contract is a source of an obligation. Because while there may have been no contract between you and your neighbor, you benefited from his lawful, unilateral, and voluntary act of saving your belongings while your house is razed by fire. Again, the principle behind a quasi-contract is that no one must be unjustly enriched at the expense of another. That is why your law now obliges you to compensate your neighbor on whatever expense that he may have incurred in saving your belongings, because you benefited from him saving your belongings while your house was on fire. How about Solutio indebeti, or undue payment? Solutio indebeti is the juridical relation which arises whenever a person unduly delivers a thing through mistake to another who has no right to demand it. Why is this a quasi-contract? Again, this is a quasi-contract because there was no pre-existing contract. A person delivers a thing or pays something to another person who has no right to demand it. For example, instead of A paying B, A instead gave the money or paid C. This now creates an obligation on the part of C, who has no right to demand it, to return it to A. Remember, here, A and C do not have a pre-existing contract. It's supposedly between A and B. But A, through mistake, paid C. Again, by virtue of the principle that no one must be unjustly enriched at the expense of another, C, having received the payment by mistake, must return the same to A. This is solutio indebeti. This is also a source of an obligation. Very important to remember in quasi-contracts is that there must be no pre-existing contractual relation between the parties. If there is a pre-existing contractual relation between the parties, then the source of the obligation is not a quasi-contract. It will have to be the contract itself. Let's go back to solutio indebeti. Your Supreme Court has given the requisites for solutio indebeti to exist. First, payment is made when there exists no binding relation between the payer, who has no duty to pay, and the person who received the payment. And second, the payment is made through mistake and not through liberality or some other cause. These two requisites must be present for you to say that there is solutio indebeti. If there is any pre-existing contractual relationship between the parties and the payment was not made by mistake, again, we cannot say that this is a quasi-contract. Relevant in this discussion is the case of BPI versus Sarmiento, GR number 146021, March 10, 2006, where the Supreme Court said that the appellee here, Sarmiento, could not be obliged to return the salary that he received. Why? Because there was a pre-existing contractual relation, and that is the employer-employee relationship between Sarmiento and BPI in this case. In this case, the bank was saying that the appellee Sarmiento must return the salary that he received during his preventive suspension. The Supreme Court, however, said, and it found, that since Sarmiento was told by his supervisor not to go to work while the investigation was ongoing, the Supreme Court said that it was because of that reason that Sarmiento sparingly went to work. And that means that during that time, well, there was an investigation and then he was given the salary was not paid by mistake. It was paid due to a contractual relation. And what is that contractual relation? Again, we mentioned this already. It is the employer-employee relationship. So it's very important to look into the circumstances and see whether the requisites are present or not. If the requisites are present, again, first, there must be no contractual relation between the parties. And second, that it must be paid by mistake. If all these two requisites are present, then you can say there is a quasi-contract. However, if one or all of the requisites are not present, just like in this case of BPI versus Sarmiento, then you can say, rather, that there is no quasi-contract. And there being no quasi-contract, in this case, Sarmiento was not obliged to return the salary that he received. that ends our discussion on quasi-contracts. If you have learned anything from this video, please feel free to click like and subscribe. If there is any other principle or concept of law which you would want me to discuss in this channel, please put them in the comments section below. Thank you for watching. See you next time in MBL Classroom.